I'd like to call to order the meeting of the Veterinary Medical Board. First thing is to remind everyone that this meeting is podcasted. So for board members, make sure that you speak into the microphone. Make sure that the green light is on. And public members, although you may be recognized while in the audience, to speak, come forward to the table and speak into the microphone. Please make sure that your telephones are on silent. I've already checked, there are no Pokemon in this room, so you don't have to be checking your phone. This is not a Pokemon gym. And I'd also like to thank board member Kathy Bowler, who has provided us with Bowler's Bees Honey. Bowler's Bees Honey. So that we'll all be extra sweet to each other today.
Some of us got some money.
Oh,
Kurt needs some honey.
Kurt is going to remain sour because he has no honey. So we'll call to order establishment of a quorum, please.
Okay. Dr. Nunez,
Here.
Dr. Waterhouse,
Present.
Dr. Nolan,
Present.
Dr. Sullivan,
Here.
Jennifer Laredo,
Here.
Kathy Bowler,
Here.
Lee Heller,
Here.
Judy Mancuso.
Here.
Okay, we have a quorum. And I am Anne Marie Delmanayo, Executive Officer of the Veterinary Medical Board.
Good morning, everyone. Kurt Epler, Supervising Counsel, Department of Consumer Affairs.
And if any members of the audience would like to identify themselves at this time?
Henderson, Veterinary Staff Education.
Jonathan Morgan, DC. Valerie Pensacola, CDMA. Ken Pulaski, CDMA. Ken Pulaski, CDMA.
Welcome, everyone. First, item number 3, review and approval of April minutes. We have an English professor as a member of our board who has taken out her red pen, and you have a revised minute meetings with some corrections in there. What grade did we get?
Not very good.
You were an A minus.
Okay.
The minus was for the technical errors.
Were
Take it.
were any of the changes substantive, or were they mostly grammatical?
Mr. Chairman, if I could, there is, I'm sorry, I thought,
Oh, it was? It doesn't sound
I
like
was just mumbling,
Sorry.
that's all. Page 18 of 19, and I want to thank Ms. Heller. Apparently, during my presentation that was worthy of going into the Smithsonian, I said something that was, upon reading the record, was a bit either unintelligible or very confusing. And so, respectfully, I think what the board may want to do is kind of defer this item, if you wouldn't mind, till we go back and look at the videotape or the audio tape, because allegedly I said, Mr. Epler noted that the significant cause for negligible harm would need to be fully articulated at the board level regarding any consumer protection concern. I know that's easy for me to say, but very difficult to understand, because I think it's a little bit unintelligible, so,
I get it.
okay, well,
I, however, did not.
yeah, so, I'm sure I might have said that. I just think perhaps if the board will allow me, just kind of defer this item and have us go check the videotape or the audio tape to figure out exactly what I said, that might be advisable, because it's kind of nonsensical at the moment.
Okay, so we will defer accepting the, I don't think that's ever happened before.
I don't think so, no.
I,
want to do it on a break.
Either that, do it on a break, or we could wait until the next meeting. It depends on, or we could defer it till tomorrow. If we can, perhaps we could just push this off till tomorrow's agenda and then tackle it then. That'll give us the time to review the tape and we can make the corrections if necessary.
I'd prefer not to defer it to the next meeting because people look for these to be posted on the website for a record. So if we could tackle it tomorrow,
Sure.
that'd be great.
Sure.
Okay.
And I do apologize. I literally did not understand what it said, and I thought that clarity in the minutes was a good thing.
Yeah.
Okay. If everybody else got it, maybe it was just me.
Then, do I need a motion to,
I think with general concurrence of the board, you can just defer that item.
so we'll just move the agenda item to tomorrow?
Correct.
Okay, we'll do that. Agenda item 4A is, this is FYI, status of pending regulations. There is one update to that? Yeah.
Yeah, in the status of the pending regulations, the first item, which is the civil penalties for the citation, at the last meeting, the board approved the amended language because it was originally or disapproved by OAL in March. That has now been submitted back to the OAL as of July 17th. And barring any more concern on the part of OAL, which I think we have very tactfully and carefully addressed all their concerns, that regulation package will be approved. And with the OAL implementation dates, it actually takes effect October 1st, 2016. So that will be one of the regulatory packages that is kind of off our chart now. Yeah, finally. Thank you, Judy. We are all gray by the time they do.
Okay. Any questions in regarding to the status from the board? Any questions from the audience? Moving on to agenda item 4B. Discuss and consider commencement of rulemaking for animal control officer training regulations. And thank you for being patient, animal control officers. I know that we've had this on our agenda for quite some time, and I'm happy that we finally have it as an agenda item. SB 1162 became effective January 1st, 2013, and allowed animal control officers to carry controlled substances for the purpose of tranquilizing animals. And one of the requirements was that animal control officers undergo training approved by the board. The CVMA presented the Animal Control and Humane Officer Tranquilizer Administration Training Guidelines to the board back in October of 2013. Those guidelines were accepted and they were made into regulations, which was also approved by the board in July of 2014. Then legal counsel got a hold of it, and that's when it was disapproved because legal counsel identified issues that did not fall under the purview of the Veterinary Medical Board, including the firearm component, which means that we cannot get into the business of training people how to use firearms, and the provisions of no alcohol or drug-related convictions, and various other state and federal laws. I'm going to hand this over to Kurt, our legal counsel, right now, because those provisions have been removed, and the new guidelines are what we have in front of us today that we're asked to review and potentially move forward.
Thank you, Mr. President and members. I want to certainly recognize the hard work that went before me, especially the developer of the guidelines. And respectfully, I thought they were just perhaps a little bit too comprehensive. They sort of enveloped, if you look at the Penal Code 597.1, the guidelines that I saw included both A, B, C, A through E inclusive. And I just wanted to point out that I believe that we are really focused on subdivision A2A. That's what we're really concerned about. So I stripped a lot of the, what I consider to be, well, valuable, but not quite within our wheelhouse language out of there, and that's the product that you see before me with some help from, certainly some help from board staff and the executive officer. So what you see is essentially a stripped-down model that I believe kind of captures the essentials with working with, like I say, board staff, keeps to the essentials and keeps to what we can, what is in our purview. Like I said, and I think it was pointed out by the president, I didn't want to put the board in a position of saying somebody is qualified with the firearm or anything like that, because I clearly don't think that's our responsibility, nor I think it's prudent public policy. So that's kind of what you see before you. I'll be more than happy to answer any questions. So I'll leave it at that. And the proper motion, if the board would agree, would be to notice this for rulemaking and commence the rulemaking process. So with that, I'll answer any questions.
Mr. Chair, I have a question.
Yes.
In both the description and the actual language, the word didactic is used to describe the training process. I know what it means, obviously, conceptually, but I wonder if it's specific enough to describe what is being expected of the veterinary trainer. So I'm not sure what is meant by including didactic and hands-on training. Obviously, the hands-on, I think, is clearer. Does that mean classroom-style training? Does
Yes,
it mean
perhaps.
provision of written materials?
We try to get, I think what we were trying to aim for, and perhaps Anne Marie we were concerned about some sort of remote distance learning concept. I don't think that's what the board was interested in. I think they're really talking about, it's not like, to make a bad joke, it's not like continuing legal education where you get your 9-iron and you go out to the 7th green and figure out, if you can land the ball within 20 feet of the pin. I think this is a situation where the board, as I understand it, really wanted the participants to be in a room where the instruction was being provided. So that's why we chose that.
May I suggest more specific language then? Because didactic just really means instructional.
Okay, certainly.
Is there language you propose?
I didn't know what was meant until just now, since I didn't, but I guess it could be, depending on what you want, face-to-face or direct instructor-student contact. I think there are different possibilities, responding to what you just talked about being the goal of the board.
Okay.
In-person training or something?
Is it-
Hands-on training.
That's what it says.
But hands-on sort of means hands on the animals or the materials as
Right.
opposed to direct contact with the instructor.
In person. yeah.
Okay, Dr. Sullivan.
I think didactic does cover it, because I don't think our intent was to put them in a classroom. It could be out in the field. It's not only materials, but it is discussion of what's going on and education. I thought it was a perfect word.
Judy?
I think also the class would be held at a conference, maybe, like the State Humane Association and CVMA, when they do this, is some instructional thing too at a conference. That's what I thought. But it's always going to be in person. It's never going to be online.
Dr. Sullivan?
I don't think so. I think it's the veterinarian that has the controlled substance permit that is responsible for a one-on-one training of this individual. It's that responsibility. I did not have the impression that it was necessarily a course.
Well, why don't we ask Dr. Segna, since he spearheaded it? Can we do that?
When we get to public.
Okay.
Yes.
We haven't done this training, but with euthanasia training at our facility, we just use a conference room with 5 or 6 employees, so it's sometimes classroom, and then we do go out in groups out to the field to do hands-on.
Yeah, my impression was that you couldn't really predict when the training needs to be done, so I didn't assume it was going to be at conferences and so forth. If
There's going to be
if an
humans
officer
in the
came on
room,
that
yeah.
needs to be trained, it's something that could be just done once they're hired and so forth. Go ahead.
I did talk to Orange County about this particular training, and Judy, you're accurate. They are looking at doing it at set periods of time, especially the recertification. So I think it's both. I think there's going to be some as-needed basis training that would be in the field, in the classroom, wherever, but there's going to be recertification that's done for the animal control officers at a set scheduled time, and they'll bring them all in and then train them at once.
So then proposed language would have to be flexible enough where all those could be considered applicable.
I think it's just never going to be online. It's always going to be in person. And so maybe if we just use in person somewhere, that'll cover it.
Mr. Chair? Just following up, didactic is just a very vague conceptual term. It literally just means sort of instructive. And if we have more specific ideas about what that should mean, we probably should provide that guidance in the regulation.
Because that could mean online, right, Lee?
It could mean anything. It literally just means teaching.
Right.
So
Okay.
if we want to be more clear about what that teaching involves, otherwise I know that if I were the veterinarian, I might not know what my parameters were for that.
So may I suggest, since I'm doing so well with runners in scoring position here, if we say subdivision C, the training which shall be personally attended and which shall be a minimum of 4 hours, does that satisfy? We can strip didactic and suggest that the training be personally attended.
I think that would work.
Okay. So then I guess I'll just be so bold, then for those of you who are following along, the subdivision C would require the training which shall be personally attended and which shall be a minimum of 4 hours, shall be provided by a licensee and shall include hands-on training.
That sounds good. Do we need a motion or anything? Just Mark just saying it's good?
Well, we
Dr.
made
Newman.
corrections, and then we'll call for a
Right,
motion
well-
to accept
Okay.
that.
So while we're making corrections on the second page, subsection F, it says at the end of that sentence, shall be for 4 after insurance. It should say 4 hours, I believe.
I'm sorry, what section was that?
Okay, so second page, this is the section
years.
2039.5,
Oh.
subsection F on the second page. After 4, it doesn't say hours, or it should be
Or
years, I
years. 4
think, not,
years.
I'm sorry, not
Yeah.
hours.
Yeah.
Hence the confusion.
Yeah.
And then what happens after 4 years? They have to reapply? Or do they have to take the coursework again? Or do they just reapply and get a license again? Or do they have to take coursework again?
This would be the recertification.
Right.
For recertification?
Yeah,
Yes.
They need to take coursework again?
yeah.
They need to
They
take the
need to
course again.
recertify because the agents change. The
Right,
control
exactly.
agents
But
change.
it doesn't exactly say that, does it? It just says they
I
have to reapply.
think,
They
let's
have
see.
to apply for a new license.
Well, my natural conclusion is if was 4 years, then they would need to take the affirmative step of recertifying if they wanted to still be able to administer this sort of thing. That was sort of my
I have no idea.
rationale.
Yeah, after this.
Dan has stepped forward.
I wanted to only speak when you finished.
Okay,
Turn on your mic and identify yourself.
okay.
I'm not
So-
done yet.
Yes, Dr. Waterhouse.
On, I know there's more than one page 2 here, but on the first page 2, so I don't think they call them MSDS sheets anymore. They've changed that system and all the names. Now it's SDS.
SDS, okay.
Safety data sheets.
What page, Cheryl? Page 2,
So that's, on regulations, that's
first
gonna,
page 2.
that's gonna apply to item D3.
Oh, we got it. And bullet points.
No, I was on this.
So you're talking about, I'm sorry, D3, review of applicable safety and data sheets for each, okay. So just strike material. And, yeah, thank you.
wording is found throughout, by the way, so it's found again on page 4 of the second document.
So the second document is really more of a background document for the purposes of OAL. Whatever changes we make to the language, we will correct in the background document.
And the statement of reasons, does that go back to the OAL? or-
Uh-huh, yeah.
Okay, so there's page 2 of the initial statement of reasons, under anticipated benefit rationale. There's a
Okay.
grammatical thing there, so by providing specific requirements for training, that should be the veterinarian.
Well-
It doesn't refer to animal control officers, it refers,
By providing
it
specific.
doesn't refer to animal control officers as it is suggested.
I think my grammatical policing is contagious.
That's-
So you're suggesting by veterinarians providing specific requirements for training, or by the
Or
board?
somebody, the board.
The
Yeah,
board. So
somebody.
we're requiring the training, but it is,
Right.
the benefit is to the animal control
I know, it's a
officers and humane
grammatical
officers. Okay, we'll say by the board. Okay.
So animal control officers can be properly trained.
Well, I think if you say by the board providing specific requirements for training, animal control officers and humane officers can be properly trained or are properly trained and educated.
To be the most correct, you would say by having the board
Yeah,
provide
by having.
specific
Okay.
requirements for training.
And then on that same page, that last paragraph, CCR section 2039.5, I thought that was written very awkwardly.
What page are you?
Page 2, under statement of reasons.
Okay. We can reword that. I see what you're saying, but we'll troubleshoot that.
Yeah.
Jennifer?
I have a question on the first page of the proposed language under 4A. The training, 4A on the first page of the proposed language, that training shall include proper administration route, drug combinations and mixtures. Does that count as compounding? There was a lot of discussion about compounding with DBMs and RBTs. There was no mention of ACOs.
I'm sorry, are you suggesting that an ACO could compound?
Suggesting that we should not.
Yeah.
Yeah, I wouldn't read it there. I think methods of administration, I would not consider that to be an implicit authorization to compound.
Would it help to remove the word mixtures? And just, because it's really the combinations that,
Sure.
if you look at the detailed language later, it talks about educating the ACOs and combinations and obviously drug interactions, right?
Well, both. I mean, they're not one and the same, but yeah, you could remove mixtures and still get the same content.
That was my suggestion.
Yeah.
Okay, so I appreciate the edits to the background document, but again, I'm reminding the board that we are going to be voting on the proposed language. And so far, we have some changes. We have changes on C, that the training,
That's where I wanted to
okay,
speak, if you don't mind.
Go ahead.
This is Diane Sokoloff from the Attorney General's office. I'm looking at this from the perspective of the lawyer trying to deal with the litigation aspect of it. And so what I think would be a clearer way to articulate this point is to speak in terms of a series, as opposed to unnecessary, I think, language in here. So something to read something like, the training shall be, what Mr. Hepler first said, I don't remember the language that you inserted, shall be
It shall be personally attended.
personally attended, a minimum of 4 hours, provided by a licensee, and include, and that is
hands-on training.
whatever you wanted to decide with there, but that's an easier way to follow it, and I think that is a improvement.
I think that sounds good. capture that?
Yeah.
Yes.
Yeah, we will.
So,
And then there's one last thing. And then since it's almost C and D therefore are similar because it's saying what the training is going to be. So you might want to add, and I haven't really thought this through, but the training shall also include, or something like that, because, or unless you have to figure out a way to distinguish what D is talking about as opposed to what C is talking about. Oh, I guess since it's the components, I think that's okay, but I would take out the word various from 2, because I think that's just superfluous.
okay.
And then my last comment, just so then I'll leave, is very, very minor, but on F, there's a typo. Just because you guys you're going to vote on it particularly. After issuance, there's an extra comma. You got that? Okay. Sure.
So may I make a stab at reading C again? Can I make a stab at reading, producing C, the wording on subsection C? The training shall be personally attended, comma, provided by a licensee, comma, a minimum of 4 hours, comma, and include hands-on training?
Yeah, and we'll finesse it. I mean, we're
Okay,
getting
so
too
that's
caught
what
up in, yeah, it's just all gonna come together.
Okay, but that's what we're trying to.
Right.
So we're leaving out the didactic.
Right.
Correct, I think Ms. Sokolow perhaps break that into a series, you wanted more of a series, which we will do as we
Okay,
sort of polish this before it goes to OAL.
so we made that change, we removed various from D2. We made the changes to the MSDS on D3. We added 4 years in F. We got rid of that extra comma because who knows how that would be interpreted.
And one more, we removed the word mixtures from subsection D
Yes.
for big A.
Because we do not want to
Compound.
give them authority to compound.
That's what they use as tranquilizers, as combinations of drugs. And it is what it is. I mean, how are you gonna make it different? I hear what you're saying, but that's the standard in the field.
Any other input from the board? Any input from members of the audience?
Dan Segna, CVMA. So I just want to comment first, as was mentioned, I was part of a work group representing CVMA that also included a representative from the State Humane Association of California and the California Animal Control Directors Association that put together the original guidelines that were presented to this board. And I think at that time, at least our understanding of what our charge was to actually develop some kind of a guideline for the veterinarian that would be doing the training. And I certainly understand, that if it's going to go into regulation, and I compliment Mr. Hepler on managing to take this 11-page document and get it down to a page and a half. So that's pretty good. And I think I went through it, and it looks like you captured all of the important parts of this. But I would like to comment on a couple of things. One of those is, and I understand why we're removing the components of 597.12B through E. I think our reasoning of putting that in there in the first place was an attempt to identify a humane officer or an animal control officer. So specifically, they had to be one of those. And so I don't know, so my question for you is, in in the parts at the beginning, I guess, which is part A, is, are you clearly stating that this needs to be an ACO or an HO? So just, I will leave that up to you to decide whether or not that is the case. The other thing that I think is important in Part A is that they meet the requirements of subdivision B, C, and D, but I think E and G are also important. It's the examination. They should complete the exam. Fortunately, the way it's written, the language says that the instructor, the veterinarian, needs to administer the exam. It might be more efficient to say that the person that's completing this training must successfully pass the exam administered by. And then, and I think G is important also because if new drugs are added to the training, then it would be important for them to have gone through that training. And I have a question for you on Part B, where it says that a licensee means an individual who holds a current and valid license to practice veterinary medicine. I'm assuming this means a veterinarian, which is what the law 597.1 states, and I'm just questioning because I think typically in the Practice Act it says a California licensed veterinarian instead of this language. So again, just a question that you can decide if you want to pursue that or not. In Part C, on the discussion you just had on the training, I think our intent was that there would be a lecture component, which was what the didactic was supposed to represent, and a hands-on component. And I'm not sure that the new language states that. It sounds like it's just shall include a hands-on, and I guess the lecture part would be implied, but I think it would be better if we included that in the language. And then I think under 3, I think I heard that you caught the terminology changed from MSDS to SDS now. Okay, that's new. And then there was also a comment on Part F that it doesn't state it, and I guess, again, if legal thinks it's implied enough that they would have to recomplete the course every 4 years, then, you know, maybe we want to add something a little more specific about that. And then just a general comment on the training. The law says it has to be performed by a California licensed veterinarian. It doesn't say it has to be the person that is actually in that shelter setting. And I know we tried to keep this somewhat vague so that it would be available to the veterinarian in the specific shelter to train their own ACOs and HOs. But also I know there are companies out there that put on extensive training, I think up to 2 days of training in this field. So we thought it was important to allow an agency to be able to hire an outside company that provided the type of training that we identified in the guidelines. So we purposely left that vague in that regard.
If I could just be so bold, thank you very much.
Sure.
I thought we kind of assumed the same thing, that there could be some contracting going on.
Yeah.
And you could contract for this training, that it wouldn't necessarily have to be the licensed DVM
Correct.
associated with the facility. It could be someone who
Right.
conducted that training. Okay.
Any questions?
Do you see the language restricts that? I'm wondering.
No. I was just clarifying
clarifying. Okay.
that we
I thought
purposely wrote it that way because we thought it was important to leave it open to who would provide the training.
Got it.
And
Okay.
no, I don't have a problem with it, other than I think we need to clearly state that there will be a lecture component, or however you want to state that.
So are you okay with the last version of that new definition about?
In Part C?
Yeah.
Well, my comment was, I think we need to more clearly state that there will be a lecture and a hands-on component, as opposed to the way I was hearing it now. It specifically states hands-on, but doesn't say that there will be a lecture component to it.
Dr. Sullivan?
Yeah, I have I guess a question then as far as how this is going to work. I assume that there has to be a veterinarian who is getting the controlled substance. And then what is that person's role as far as connecting with that officer? Does that person have any authorization with this to have any control over this person, or are they two separate entities?
Well, I don't know that I can answer that. I'm sure it will vary from agency to agency. But, part of what we put in the guidelines was information for the veterinarians about their requirement in obtaining and storing and recording the controlled substances. So in the end, it's going to come back to the person holding the DEA license. And they are, and I think the language also states it can be under direct or indirect supervision. So it's going to be like many other things in the practice act, that it will be up to the individual veterinarian to determine, number one, whether they want to let any or all of their animal control officers carry and administer these drugs, if, what the relationship will be, if they'll only be sending out enough for a single day use, whatever. I mean, that will be up to them, and it will be, their DEA license and potentially their veterinary license on the line if they don't follow all the rules. So,
Mr. Chair? I wanted to follow up on Dr. Sigma's suggestion about, instead of simply dropping the word didactic, finding some way to clarify that instructional component without necessarily saying, it has to be 4 handouts and 25 minutes of lecture. But the reason I had flagged the word didactic is just that it's very abstract. But it sounds like we want something in there that would clarify an instructional component other than just hands on the animal, because that is a form of instruction as well. I'm not the veterinarian, so I don't know what that ought to look like.
well, I just suggested the word lecture and hands-on, but
So
I mean,
what I
that's
would
just,
propose is to keep it as we stated it, but the very last part of the sentence where it says shall include hands-on training, perhaps, and shall include both classroom and hands-on training?
that would be fine.
Both lecture and hands-on training.
Either one, just something to indicate that there's got to be an instructional component other than just,
Yeah, I think it's probably wise to leave out the word lecture and use classroom,
Okay.
because there are other modalities in the
Oh,
classroom
yeah,
besides
because-
just lecturing, problem-based learning, case-based, small
sure,
group studies.
that's great, yeah.
I would agree with that.
So I think classroom does a good job.
And it eliminates the possibility of online, even though you stated that earlier, so.
And thank you for clarifying the original wording, and it was helpful.
Sure.
So did we propose classroom? Is classroom
I think that
gonna
sounds better.
incorporate everything?
Yeah.
Ms. Lee Heller, does classroom satisfy the?
That was me nodding enthusiastically.
Okay. And I think is that the only change then that?
Those are the end of my comments, unless
I think
anybody
there's
has any questions.
One more, thank you very much. I think we should include, it as my oversight, in A, I think you raised an excellent point, subdivisions B, C, D. I think I want to add E, because E is the test component.
yes.
So I would like to add E. The other two, F and G, I'm not quite sure fit in there, but I do believe certainly that E does as well.
Okay,
Fits in subdivision A, as I lead off with subdivisions B, C, D, I'd like to add E of this section.
Well, there is
Yeah.
he's stating it in the list of A right now where it says that the requirement of subdivisions B, C, and D, add E. But again, I would suggest that maybe that be rewritten so that it is completion of the exam rather than the instructor administering the exam.
The passing
I'm not
of the
very smart,
exam.
but I
Yeah,
do.
yeah, it's yeah, and whatever a passing score will be.
So on E, actually I'm confused. So on the second page where it says E, we're going to add,
No. So if you look at subdivision A on page 1, subdivision A, it says for the purpose of compliance of section 5, blah, blah, blah. And
Okay.
Training that meets subdivisions B, C, and D, and I like to insert E.
okay,
And that's all we're doing. Yeah.
okay. But also on page 2, in section E, we're going to add that the trainee needs to pass. The licensee shall administer an oral or written examination.
That makes sense.
We can say at the conclusion of the training, the animal control or humane officer shall pass an oral or written examination as provided by the licensed veterinarian, which shall cover the required curriculum and shall include practical.
Chair Nunez, is that not covered by subsection F, that they have to successfully complete the course, or do we need to specify what successful completion is? Is that the stumbling block here?
While it is in F, I was referring specifically to adding a requirement in A that they had to successfully pass the exam. So,
I understand your point.
yeah, I was just responding to
It
that.
has a bit of a flaw in it that I just recognize, because basically what you want to say is the attendee shall successfully complete the examination
Right.
offered by the licensed veterinarian.
Okay.
And the licensed veterinarian is the one writing the test?
Giving the
Again,
test.
it's up to them.
Are
They-
we administering one test statewide?
No.
Or is anybody administering one test?
The intent was for the person giving the instruction to administer some sort of an examination to be sure that the people that they're teaching understand the concepts that they were giving relative to drug dosing, scheduling, storage, record keeping, et cetera, all of the things that were covered in the, in the previous
And
section.
subsection E does specify that the licensee shall administer an oral or written examination. So there's flexibility
Yeah,
for the veterinarian, which I would
So, and that
presume they want.
veterinarian is the one determining what a passing rate is.
Correct.
yes.
And I think any fine tuning can be done by staff. Is there
I just have a last question. So we captured everything that was pertinent to the veterinary medical board, but all the other stuff about the handgun, firearms, yada, yada, it got taken out. But these were originally they were guidelines, right? And so where does that information go that people still have access to? Those are still components of the overall program. It doesn't fall within our purview.
That's already in penal code. All of that is in penal code.
Okay.
And so my only suggestion was just to make sure that we reference that only animal control officers or humane officers are acceptable candidates for
not-
this training.
It just calls out to that.
Yeah, part of it said when we were asked to provide this, we were given the idea that this would be a guideline for the veterinarian that was doing the instructing.
Right.
And I think it would still serve a good purpose in that regard, and if there's any suggestions on any changes to that. But for those shelters that want to do this, I think that maybe the Shack or CACTA might want to make this available to their people to be able to use the guideline when they're training so that they know the types of things that they need to cover.
Got it. All right, very good, thank you.
Okay?
Thank you. So, any other additional comments from the public? Then, is there a motion to accept the proposed language with the changes we've just discussed?
I move that we accept the proposed language as amended and as going to be grammatically clarified by staff.
Is there a second?
Also, that I guess inherent to the motion would be the fact that with the approval of this language, the board is going to notice this for rulemaking and set the matter for public hearing.
Yes.
It's been motioned and seconded. Is there any additional comments from the board?
Yes, will the public comment, since really the public has participated in creating it, so I'm not anticipating much public comment, can it be like, there's public comment period and then the hearing, and if there's no hearing, then it can just go straight, right? I just didn't want to delay any more time. Anne Marie knows where I'm going with this, okay.
So the board has an opportunity to not set it for hearing if they're not anticipating any objection.
Right.
And we've done that in the past, like with the cite and fine regs. So if you want to go ahead and just notice this for a 45-day public comment period, absent a hearing, we can do that unless one is requested, and then we're obligated to hold one.
Yeah, you're
Is
a
that
mind
agreeable?
reader, thank you. I barely got that out and you knew what I was talking about.
So in other words, what she said.
Well, we've done that, yeah, just to help expedite it, so that's what I wanted to make sure we do, because I'm not anticipating any.
Any additional comments from the board? additional comments from the public? Hearing none, can we call for a vote? Roll call for a vote, please.
Dr. Nunez?
Yes.
Dr. Waterhouse?
Yes.
Dr. Nolan?
Yes.
Dr. Sullivan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Aye.
Thank you.
All right. Before moving on to the next agenda item, I'd like to make a change in order. On the agenda, I'd like to move agenda item number 7 up, and then we'll come back down to agenda item 4B. For the members of the viewing audience, you may not have seen, but during that discussion, there was a camera crew that came in and set up. And I was wondering what they were here for, but then they left, so they may have realized they were in the wrong meeting or something.
I thought it was because I went up there.
I was getting a little nervous about why they were here, but who knows where they went to.
Bryce, did they say anything to you?
No, I know them, so we could find out.
Okay. Just curious. Thanks.
Then we have before us the august John Klingborg, Dr. John Klingborg.
Good morning, thank you. Pleased to be here to give you the report from yesterday's Multidisciplinary Advisory Committee. Do the board members have the packet from yesterday's meeting? I don't know if that goes out with you or not. Okay, that's okay. That's fine.
Actually, you have the agenda in your 7,
You
a single page.
have the agenda and you have the priorities.
Okay.
Yeah. Oh, the entire MDC packet. We don't send that out to all the board members. It's a lot of information.
Oh.
The president has it. But if there's anything we need to refer to, we can make sure we have it available.
Okay. And then what I will make some references to some items in the packet, which you will find online, of course, as well. Okay. I'll make it so that you don't need to have it in front of you here. So running through our agenda, again, great meeting yesterday, lots of discussion on a number of issues, and we're going to kind of dig into that, and I'm going to bring you up to speed about what we did with our several hours yesterday. First off, I have to note that our meeting minutes yesterday were the most thorough I've ever seen, so I have to thank Nina in back for doing that because she did an amazing job. Yeah, really captured the meeting beautifully. So our first actual agenda item was our complaint process audit task force. And as you know, this task force has been looking at complaints that have been randomly selected by BMB staff, and they have really kind of drilled down into that. Dr. Jeff Pollard and William Grant II have been going through that, and have done a dynamite job and have provided a number of reports over the past over the past year that we've been doing this. And those reports are excellent reading. They're very dense, and there's a lot of really good information there. And the idea here is that a lot of this information is going to percolate up to the expert witness training program. And so as we do this, not only is it kind of a safety check on our system, and is our system working and where things need to be improved, but also that is immediately brought back to the expert witnesses in the training capacity. So a few things that came up as we look at that. First of all, they felt there was a clear demarcation in the cases that they were seeing before 2013 and after 2013, and that in general, just the quality of the expert witness and the way that the cases were being evaluated had improved. They note that there's still not a standard template that they're following, and that there was some discussion about how the process that they work through may actually affect their outcome. So we were talking, we did not codify a process for them to read the medical record first and then read the complaint and then look at this and then look at that. So we didn't get into that detail, but we talked about the fact that thematically, there may be a preferred order of going through this. The idea being that in some cases, perhaps if you've read the complaint first, you then are going through the medical records with a different lens, a different filter, than if you're just looking at the medical records and going, oh, okay, I can see why they did that. I can see how this happened. And then you see the complaint and see where things seem to potentially have gone awry, or there was an issue, at least from the perception of the complainant. So anyway, a good conversation there. And again, part of the, I think, philosophy of creating a great expert witness as we try and cultivate that program. There was a lot of information that some of these cases do gather that is not helpful. And so it's unsubstantiated facts and it's anecdote. And so trying to, again, help an expert witness filter through that and put a pile of fact and then a pile of hearsay and give them appropriate weight is part of that training program. What else can we say here? In the majority of cases reviewed, the respondent provided an ineffectual response letter, or worse, no response letter to the complaint. This may suggest A, they misunderstand the enforcement analyst's request, B, they don't take it seriously, or C, they follow ill-informed legal counsel, or finally D, other. And so we did spend some time talking about that and the fact that we need to try, not necessarily to help the respondent, but to improve the transparency of this, that this is not something where somebody's out to get you. In many cases, this is an educational process for the licensee. So again, good conversation there. Our plan at this stage of the game is to continue to do once or twice a year review of various cases. So that's where we are at this stage. I think we've kind of got some of the meat and potatoes, and so now we're going to get more into an auditing mode at this point. And as chair, I'll be rotating probably with 1 or 2 year terms the individuals that sit on that subcommittee, and just so that we always have fresh eyes going in on it. One thing that came up yesterday is we had not at this point looked at a complaint that had involved an RVT. And so we'll probably put that on our to-do list for the next go-around as well. So that is our first agenda item. I guess the subset of that, well, actually, the next agenda item is the report from the Expert Witness Review Subcommittee. And so this was our subcommittee that was really looking at the training manual and going through that. And there was additional wordsmithing and some language there, and again, kind of the philosophy of how one should work through a case. And so good information. Don't know that we need to spend a lot of time on it, but that's information that will be moving forward as we train the expert witnesses. Our next agenda item was an update on the minimum standards for their alternate premise.
Can I just,
yes, go ahead.
make a comment on,
Please.
on the complaint audit task force and what's coming out of that? I was very impressed with the expert witness trainings that is being put on by Dan Sokoloff and Candace Rainey. A lot of our expert witnesses have commented that they never have been through training before and how much they appreciate the training that's being done. And I hear that with each and every session it gets better and better. And I'm happy that we know that they're not going to be with us forever. And I'm also pleased that there's actually handbooks that are being established to kind of pass on to future people in that position. I think that's very good. I think we've done a great service by doing that. And if any of the board members haven't attended the expert witness training, including myself, it's definitely something to go to.
Yeah, I just wanted to add, I went to one training a couple of years ago, and then I went to the 2-day training in May this spring, the new version of the training, and it's really well done. The organization was excellent, the materials were excellent, and I think the flow went very, very well, and you could tell people really got a lot out of it, because there's a whole legal side, but there's everything else too, and it was very well done. The staff did a great job, so thank you.
I have a couple of things. So 2013, when did Diane start her training? Was that around that time period? Because there was no expert witness training prior to what you did, correct?
I believe so.
So, and I did that expert witness training, it was very good. And so when you said a template on how to go through the cases, I thought that that is what Diane has already put together. So you said they're not using a template, or is it missing from the training manual?
It appears that they're handed a stack of information and then that they are sorting through it. There may be a proposed template, and I don't know that we can mandate that they have to follow a certain cookbook, but my perception, again, from what I'm hearing now, is that it seemed to be somewhat random.
Okay.
Candace is approaching, so she
Great.
May I make just a couple of comments?
And then I've got a couple more though, but after are you gonna help answer that question too?
I am. I'm going
Okay.
to try. I think what Dr. Klingborg was referring to, the comment from the task force was that the information in the complaints that they were reviewing
Yes.
didn't have a consistent format. We've now provided that. So included in the training was a template, and actually quite a few templates, depending on the type of case that it was. Did it have consulting veterinarians, et cetera? So that's something that they have now.
I
Does
thought
that help?
some of these things have been resolved.
Mhm.
And which brings me to the next question, which is expert witness retention. Since we now have this training and things are going better, are we keeping our expert witnesses?
So far.
That's good. And then the next thing from Dr. Klingborg is, number one has been on the priority list for a while, and I know that it took a long time to get through the cases, but when do you anticipate wrapping it up, and what does wrapping it up look like? Is it a final report that just gives us your findings of analyzing all these cases, and then a roadmap on where we go from here to make things better, and then it's done and you do this auditing a couple times a year? So A, what's the target completion date, and B, what does it look like when it's all done?
So our thought was this was going to be an ongoing priority where once or twice a year cases were going to be reviewed, and then there would be some report forthcoming.
Because to be honest, I mean, things were not organized as organized in the past. It was a lack of staff, lack of resources. But now with figuring out what has gone wrong and why and analyzing these things, I would hope that we could learn from it, put something in place and move on through our other priorities. So leaving it open, I kind of disagree with that. I think there should be closure, which is this final report, and, you know, here's our analysis, here's what we learned, here's what we can do better, and, you know, and who has that been assigned to make things better, right? That closes number one off, but then somehow we put an ongoing thing somewhere that is once or twice a year there's auditing. But that we close out number one and get it off the list, because it's been there a while. And it's worthy, but so are all the other things underneath it. And it seems like we should be getting there pretty soon. Does that sound right, or what do you think?
I'm going to defer to Candace and
Okay,
Anne Marie
yeah.
in terms of what they'd like to see.
Yeah.
So I think we've done that. So yesterday, when we had this discussion before the MDC, and my question yesterday was, should we see this on a future agenda? And not necessarily, because Now it's more of kind of this ongoing audit of cases, and if there's anything that bubbles up, discuss at the MDC level, we leave it on there as kind of a function of the MDC and rotating members to provide that audit. But in terms of all of the recommendations and suggestions that have come out of this group to our expert witness training and to our process, I think we have closed that gap. At least that's the way I feel about it. And Candace and I spent a
Absolutely.
great deal of time with Dr. Pollard and Dr. Grant every time they've come to visit. And this last time, I think we all had a meeting of the minds, and that was expressed yesterday in terms of what we need to do today to make the process more clear for our experts and to make sure that the outcome, we have greater consistency in how we're applying expert review to our cases.
So can we get a final report with the recommendations and close it out?
I do agree that all things must come to an end, of course, but I would encourage you to really go back and watch the MDC committee, especially this portion. There's so much great things that are currently being done that I don't think the time to talk about closure, we've reached that yet, because I think it's just going on such a good roll right now.
So you think they're still in analysis mode?
I do. Dr. Klingborg touched upon it, but it will affect a lot of things, especially our, the one issue in our sunset review was the amount of time it took for a case to resolve. This is gonna affect that. Especially Dr. Klingberg mentioned that we've made a lot of progress in how respondents are responding to the complaint, because in the past it's been such an adversarial relationship between the licensees and the board. And I'm happy that we're starting to make changes about that I would like licensees to realize that the board can be a resource, not necessarily the big bad enforcement officer. Because it does hinder the process, and sometimes unnecessarily so. And the other thing that's coming out of that is, especially for our expert witnesses on how they read these cases, one line came out of that discussion is that the deviation of standard of care, regardless of the outcome, is what the board should be focusing on when they're reviewing these cases. I think that's really a powerful statement. And the other part that's been coming out of that training that the expert witnesses need to know is how these deviations apply to the Practice Act, which section of the Practice Act is being violated, and therefore that's useful information for the next process. There's three components to an investigation. There's the information gathering section, the expert witness review, and then the part that Diane takes over. I'm not sure, what's that referred to? Formal discipline process. It's really exciting.
Well, I'm happy to hear that, and I'm actually very glad to hear it. And maybe, because I think what we've heard in the past from licensees a lot too is, sometimes they get these notices and they don't take them seriously, they just want them to go away. Maybe if I ignore it, it'll just go away type of thing, and then it doesn't, it really nips them. And so maybe there needs to be something on our website too that's friendly, like, I just got a notice with some little cartoon, with the guy's hair coming out or something, like, oh no, my God, right? What do I do next, And maybe when they click on that, it isn't as scary, and it's more of the education outreach than what they might first perceive it to be. And instead of ignoring it, maybe it's easier.
The other thing they do is lawyer up, which really delays a lot of things.
Say
lawyer up.
Well, the board the staff is doing a great job now as respondents call with questions of actually talking with them, and I think helping, so.
It's a big deal.
Yeah,
because if you can get it resolved immediately, that's always the best thing to do for everybody and everything.
That's what I took out of the meeting yesterday in the audit, that there was much more discussion between, so the respondents really were clear on what was asked of them. And it wasn't a, you know, you can't talk to them because they're on one side or the other.
Right.
And the staff is much more engaged, so
You know, in the
congratulations.
old days, the letter would go out and it would basically say, we want the files on this animal, and you didn't even know what the complaint was per se. So those are the old days. So now the issue, the complaint and the time range of that, when we want the files from this date to this date is part of that. And so, you know, there's, again, a lot more transparency about what's the question.
That's good.
Dr. Sullivan?
Well, we can all kumbaya up here, but if I get a letter from the Veterinary Medical Board that has a potential of taking my livelihood away from me, it's going to be adversarial. I think the staff attitude has changed dramatically, and that's a positive, and we must continue down that road, but that's the only thing we can control. If I'm sitting there and get a letter, and I've had a problem with that client, even though I think I did everything correct, it's automatically adversarial, and I don't have a problem with that. What I did have a problem with is how our staff was handling things years ago. That has changed. That's the only thing we have control over on this board. I also want to address a comment that John made about changing the, first of all, there isn't any part of government or even us out in practice that doesn't have some type of oversight. And I think the review of our processes need to continue with oversight of this committee. The good is on changing every 2 years is that board members, or I should say MDC members, get to see and learn what the process is. That's very important. However, the bad part is what I heard Bill saying yesterday was after 2 years of working on it, he all of a sudden had an image of the problem of the process. It was very minute, but it was critical in how the analysis was. So, you know, I think 2 years is a short term. I think it should be longer because I think the benefit is the repeated overview of the process gets into a deeper level that I think needs to be looked at. So that's my 2 cents worth.
Thanks for taking away my kumbaya moment.
You negated your kumbaya.
If I may, I think it's important to note too that the continuation, the changes that we're making now, we're not going to see the fruits of that labor until a ways down the road. So, you know, whatever we're implementing with regard to how expert witnesses prepare their reports and so forth, that comes back to the board and then it goes through the AG process. It could be a year and a half down the road before it would make it to that committee for evaluation.
Mr.
So-
Chairman, can I agree with Richard in what I might suggest, not wanting to do your business at all, John, but maybe alternate appointment so that you have some continuity, and if they could serve longer terms but have a newer person come alongside them might, but again, you are.
We have staggered terms right now, and I actually need to reach out to the people serving that to see how long they want to continue. So part of this is not burning out my folks. So we do have that. You know, we're hamstrung by the Open Meetings Act from the standpoint that we would love to have a third person kind of in the queue and getting trained up, but we just can't do that. So it's going to be 2 people, and we're just going to have to work that out. But, yep.
Yeah, just one last comment. I think of being on the board this period of time, I think the cases that we're seeing coming through are handled much better than previously. I think we're already seeing that. I don't think there's a big lag time here. I think we need to continue to improve, but I mean, whether it's good or bad, what I'm seeing is a lot more stipulated settlements. So I don't know if that's good or bad, but they're a lot cleaner. And, you know, there's admittance of guilt and there's a penalty, and, you know, I think that speeds up the case. I'm not sure they should be all going that direction, but That tells me that I think the lawyers on both sides are recognizing that what's in front of them is real and they have to address it, and rather than two expert witnesses in a court. So I think we're seeing the results already.
Okay.
So thank you for, discussing that in greater depth. The fact is that this was a huge agenda item for us yesterday. We spent well over an hour discussing just this, and, it was a 3-page report and generated this much discussion because we recognize the importance of the conversation. Judy, you partially get your wish because the expert witness review subcommittee is going away. That is the end of one of our existing priorities. And so we are trying to move some things into the outbox.
I just like closure when, that's all. It's
I'm
going
right.
on things so long. And
I
so,
completely agree. Our next agenda item was the update on the minimum standards for alternate premises. And as you recall, CVMA has a task force and has invited various stakeholders, including representatives from the MDC and Anne Marie as liaisons to serve on this task force, and have tackled a variety of issues. Most recently was language within shelters that would allow RVTs with written protocols to provide various services. And those are going to include diagnostic tests and treatment, and basically some things that are time sensitive for these animals that come in that have been impounded, that have been seized, that have been abandoned or whatever else. And we're not ready to move that language forward. We're going to be meeting with the shelter community at our October meeting. And so this conversation that we had yesterday, again in some depth, was really about trying to grab as many different ideas and concepts and try and sort of expand the conversation so that we can be as inclusive as possible and try and solve as many things as we can. Some of the things that we picked up on that were amending the VCPR potentially for the shelter setting, because we don't technically have a veterinary client relationship, and in some cases, especially if the animal has been surrendered or seized, the client isn't really the client anymore. They have abrogated their rights to the animal. So we need to consider amending the VCPR for that set of circumstances in the shelter setting. We still need to define what a shelter setting is. There's that comes in many flavors. Consider whether or not an RVT could be a managing licensee of a shelter. This would create a new task or an extended duty for RVTs, so that's one of the conversations that we'll be having. There was some discussion about induction of anesthesia versus sedation, and we're actually going to ask for this to become a priority. So we know that RVTs can induce anesthesia. At what point, when an individual is out in the field, animal control officer, RVT, is the use of that pharmaceutical sedation and allowable versus anesthesia and not? And where do we cross that line? And we had a completely inconclusive conversation yesterday about, was it the intent of the drug or what? So again, that is something that we want to capture and come back to and try and work through in our group. So again, we're trying to figure out what the overarching issues here, and how does the Practice Act apply to the shelter setting? How does it apply and how does it not apply? In other words, where might there be exemptions? And so we're still not ready for prime time on that because it is a big, big issue. The language that had been put forward through the CVMA's Premise Permit Task Force was excellent, and it's a very, very good starting point for us, a great scaffold for us to build on. So they really did a dynamite job, and we appreciate the effort there. Again, we'll have more for you after our October meeting on this issue, as it's going to be one of our main priorities.
In regards to the VCPR, I know we had a somewhat similar discussion when we were talking about vaccine clinics and how a supervising veterinarian didn't necessarily do a full and complete physical examination on all pets that came into vaccine clinics, and yet they would establish a VCPR. Do you think somewhat of the same reasoning can be applied in a shelter situation?
Well, I think that the difference in a vaccine clinic is it's, you know, the VCPR, the relationship that you establish with the client has to be appropriate for the service that's being provided. And so with the vaccine clinic, the bar in terms of the need for a complete physical exam, et cetera, is potentially not necessary if the owner has authorized you to provide the service. It's when we get into heartworm testing and interpreting tests or other things that require prescription medications that then the full VCPR, if you will, takes hold, because now we're talking about practicing medicine at a little bit of a different level. We still don't have a client in the shelter setting, so so that is our issue. I don't know how we resolve this other than with some form of exemption, but we still, and the language here definitely still requires veterinary oversight and awareness of the animal population. It's the client component that's cut out. So, yes.
Well, and all the health and safety code and public safety code that refers to dogs and cats in shelters, the shelter owns the animals. I mean, once there's an owner relinquish.
Well, do they or don't they? I mean, you know,
I have code that I've regularly tried to change and whatnot that I could probably highlight and send you that says that the ownership goes to the shelter, even though Val's shaking her head no.
I think they're a repository.
I guess the question is particularly
is that the word?
After an owner term period, and then with a stray, after the stray hold period is up, is on whose behalf are they holding the animal after those legal holding periods are up?
They belong to the shelter. I mean, if you can euthanize them, then, you know,
I think
whose behalf are you euthanizing them on?
The presumption, certainly in the shelter system in which I've worked, is that it basically belongs to the county if it's a county shelter. It belongs to a municipal entity.
Yeah, I'm going to stop this right here because the ownership issue in regards to pets and shelters is not on the agenda.
Our next, so that was that agenda item at this point. We're still in process. Next agenda item, update on the survey of public and private shelters and a discussion of minimum standards and protocols for shelter medicine. So part of this then is trying to get out to the shelter community as we create premise permit language, as we try and figure out what needs they have to serve their population of animals and also the consumers. We have developed the survey and sent it out, and we're still in the process of it coming back is what's happening. We've got two issues, and one is that there's been a delay in getting the survey back, and the second is with the data analysis. The program that Dr. Druses is trying to put this into is behaving like a computer program is, and it's misbehaving. So we hope to, work through that, and we'll expect to have that data at our next meeting. So the report was, we're working on it as far as that goes right now. Our next item was the review and discussion of the veterinary student exemption, and what we have here really is still a lack of clarity in terms of what a DVM student may do at what point in their educational process, and do we treat first and second year students different than third and fourth year students, and so on. What we need to do is clarify that particular exemption language that's in 4830A5 that exempts DVM students of UC Davis and Western U from having to be licensed, basically. So we need to clarify that. At the same time, we need to make sure that we're protecting the consumer with whatever language we develop. We need to create guidelines and objectives for the distributive learning sites. That's an externship or some other off-campus site that's not affiliated directly with the university, but has a memorandum of understanding, has some defined curriculum and some tool for measuring what the objectives are and whether or not they were accomplished. So we need to have that. And what got brought up in the middle of 4838.5 is a regulation, CCR 2027, which basically allows junior and senior veterinary students and graduates of an AVMA accredited school to function in the capacity as RVTs. And the concept for this was that those students had enough training, at least a couple of years under their belt, that they could go out in the summer or during vacation and they could get a little bit more hands-on experience up to the level of an RVT, not certainly beyond that. Where we have a bit of a boondoggle is the graduates part of it, because the way that this is written, somebody may graduate and for whatever reason never pass their DVM licensing exam and could essentially function as an RVT forever and yet not be a licensee. So we need to fix that. And we're in the process of doing that. What we're going to do is actually form a work group of MDC members, UC Davis and Western University. And so we should have specific language at the next MDC meeting that we may vote on and then bring to you. But at this point, we wanted to make sure we had buy-in from all the players. Any questions on that? Our next discussion was a discussion and consideration of, quote, extended duty, unquote, for registered veterinary technician regulations. And we have no recommendations at this point. So we have had a subcommittee that has met and talked about it. There are still questions about whether or not there are specific extended duties that need to be performed by RVTs that will benefit the consumer. I think it has been clearly emphasized from the get-go by the individuals of that subcommittee that what we're looking at here is access to veterinary care and improving care. It's not necessarily about creating new job tasks for the RVT profession or for anybody else. This is where are their bottlenecks in access to care. And it's a complicated question in terms of access and the consumer, because our consumer has both 2 legs and 4 legs. And so who is that consumer? And so we're working through that. I had asked at the last MDC meeting in April to have the professional associations that represent RVTs, both CARVTA and CVMA, to go out to their RVT membership and get back to us with the laundry list of what extended duties they saw were necessary. And CARVTA's board has not taken up the issue yet. And so they had no report for me on that. And so I've kept this on, I'm asking you to allow me to keep this on the agenda, because I've given these groups a deadline of next meeting, let's have a discussion about this and let's figure out where we are. Yes.
So there was some discussion yesterday about the terminology of this point, and so maybe we could just call it duties of RVTs instead of, and leave out the extended, and would that make you happier?
Well, duties are something that are already defined in the Practice Act, and I think a question came up, and I don't want to belabor this conversation because it can get out of hand, but the question came up, you regulate duties, why can you not now tackle extended duties? And this is where we go back to, it's not the board's job to promote or evolve the profession. That's the job of the associations. Our job is to respond to the consumer need. So frankly, I think I've been, pretty clear about how I feel about this. I think we're a little out of our element here and out of our role as a consumer protection organization. I recognize the need to keep it on the agenda to allow folks to bring this supporting information possibly before this board that says, hey, we've got a true consumer protection issue here that needs to be addressed by somebody. To date, we have some of that with the sheltering community, and that is being addressed under the sheltering agenda item. So I don't think it matters right now, the terminology, because I think we've already been on record to say The job of the Veterinary Medical Board is not to advance the profession. The job of the Veterinary Medical Board is to respond to a consumer need or an access issue as it is communicated and supported by some set of facts and circumstances. And I think we're doing our job at this point by responding to those facts about shelter medicine.
The CVMA RVT committee has also not met, but their liaison to the board, Leah Schufelt RVT, spoke yesterday. She did send out a message to her cohort and asked if there were any extended duties that they foresaw, and there were no responses. And so my response to her when I heard that was, that's a response. No response is a response. Cindy Savely, RVT, from the Sacramento Valley Veterinary Technicians Association, said that her board met and had suggested that in a shelter setting, rabies vaccines, parasite control, and wound debridement be considered as extended duties. So that was something that we heard there. The shelter setting was mentioned by a number of individuals as the place where we might see our quote-unquote extended duties. And it's advantageous that we're going to have a good cross-section of people from the shelter community at the next meeting so that we can discuss that. Again, it was also, so we got ahead of my script. It's also iterated and reiterated that our mandate has never been to change the role of RVTs per se. We look at every issue, but we do look at every issue that comes in front of the MDC as to how it will impact RVTs. And in fact, as issues have come up, we have been very forward-thinking. So from the very inception of the animal physical rehab conversation, our very first document included RVTs in that. And our very first document that we saw at the MDC level on compounding also included RVTs on that. And that constant presence is not going to change. It is also worth noting that the two members of the Extended Duties Committee for the MDC are RVTs, and they move forward with no recommendations at this point. So we are going to wait until next meeting. We will hear what the professional associations have to offer, and we'll move forward from there.
How are you reaching out to shelters, shelter folks that are going to show up next meeting?
I have no idea.
Okay.
How are we reaching out to shelter folks?
So we have already, the subcommittee, that being Dr. Drusi's and Dave Johnson, have already reached out to folks. I'm working with Erica Hughes of the State Humane Association.
Oh, good.
So they're aware of our.
I would say CVMA, CACTA and SHAC, if they could do some kind of a blast.
They are, and I've talked to.
That'll get everybody pretty much.
Yeah.
Yeah.
And I've talked to Eric Mills at CACTA as well.
Oh, wonderful. Okay, thank you.
Okay, great. Our last agenda item before we get to our priorities list is the review and considering regulations regarding veterinarian RVT authority to compound drugs. And as we know, we work on a wide variety of species that come in many sizes and shapes and face many ailments. So compounding is here to stay. The question is, how do we do it? And what are our limits? And so we're in the process of developing language right now to do that. It's a big task. We're going to get as much input as we can from the Board of Pharmacy and get their help. And I have been on the phone already this morning with AVMA because one of our challenges here is we can't get out in front of what's going on in the federal government, but there are some things that the feds are doing which are still not finalized. They're guidelines at this point. And so we have to be careful that we don't try and write a document that goes outside of what's legal, of course. And so that's a process. We did have a UC Davis oncologist and an equine internist in here yesterday, and they were discussing many of the challenges that they've had with compounding, but also the ever-present need for it. So we know we need it. We just got to figure out how to make it work and make it work right. So that takes me, yes.
Yeah, are you going to speak to number 6? Because that's the one I have a few things to talk about.
Well, I did, that was
Standards
that was
for
the,
rodeos?
oh, we're talking about, you're on the priorities, yeah, let's go through them in order, okay? And so, existing priorities, evaluating the structure and audit of enforcement case outcomes. We talked about that. The expert witness subcommittee has gone away now. The minimum standards for alternate premises, still working with CVMA on that. The shelter medicine subcommittee, we're in the process of collating those results. 4830A5 and 2027, the DVM student exemption, as you know, we'll have hopefully finalized language for you at the next meeting. Pursuing extended duties for RVTs, again, we're going to tackle that as a line item one more time here, but we're always thinking about RVTs. Develop regulations to implement, develop compounding regulations, basically, again, in process, and we hope to have language at the next meeting, but that's a huge, huge task. Item number 6 is develop standards for on-site veterinary care at rodeos.
Okay, so if you look at the minutes, page 8 of 20, Lee Heller moved and Judy Mancuso seconded the motion to recommend that RVT should be allowed to attend rodeo events and provide emergency care within their scope of practice, with the veterinarian placed on call, and add this item to the MDC's priority list as the board's official response to the legislature. What I thought that we were doing as well, and not as just putting it on the list, and maybe this is another one if we get the recording going that we can listen to. I thought that we were asked by the legislature, hey, do something. And I thought that this was the hey, do something that was going into the Sunset Bill.
So, Dr. Sullivan,
At the time that we discussed that motion, that motion, I did say that all of that is legal and in place right now. It's covered by 2069, which is emergency animal care that RVTs can do. And it's a list of things that in an emergency situation they can do. So if an RVT is at the rodeo, they already have the...
Can do but not mandated, right.
Right. And so that's issue number one. The thing that, there's two other things that complicate the picture. One is these animals are owned animals. So we can't mandate that they be taken care of by X veterinarian. They're owned animals, that owner has its own veterinarian. Whether it's being done humanely or not is a different issue. And I think that should be covered not by the veterinarian on call, but should be covered by animal control.
Well, wait a second, you gotta come...
Just a second, I'm
Okay,
not
go
finished.
ahead.
When this was originally put in, it put an onus on the veterinarian, and that's not our capacity. I don't know how it got in there or why it got in there. This is an animal control issue.
No,
well,
because of horse racing. If you look at animals and entertainment, and you've got horse racing and you have rodeos, those are the two things that are comparable, that you are, exhausting this animal, using them for this. And the horse racing people, they have their vets, they have multiple vets. Like you said, their own animals, they got their vets there, right? And there's all kinds of regulations. I'm speaking now.
But Judy, I'm gonna have to
Then
stop
this-
because this isn't an agenda issue to talk about the rodeos. It's a priority. But I'm gonna answer your question, because your question is relevant to the priority of it. But now you're getting into the extent of what happens
It's
at a
on the
rodeo.
minutes, and it's here,
Let
and
me
it was
answer your
supposed
question.
to be
But we
in
can't talk
Sunset.
about the issue
Okay,
because
go
we
on.
didn't
Go on,
agendize
I
it
get it,
for
I
that
get it,
today.
I get it.
Let me answer your question.
Okay.
The minutes are accurate, and what we said we would do is respond to the legislature. We did that in the Sunset Report. The legislature chose not to put it in a bill. But in our response, it wasn't our issue that we put forward as our Sunset issue. It was an issue that the legislature brought up from an outside source.
Right.
We responded to it and we said, RVTs are lawfully able to attend rodeos and provide emergency care under the current law. We wrote that in our sunset report. We also agreed to add it to the MDC's priority list, and it is there. It is also going to be agendized in October for discussion. So we can answer that question. We cannot, however, get into a discussion about what should or shouldn't happen at a rodeo.
And what I'd like to add to that is, at the last meeting, our response to the sunset hearing was put before this board, and we gave a response, and we voted unanimously on that response. We answered the legislature response to this question. I also understand what some members of the community are asking this board to do. They're asking this board to kind of take the lead and provide some sort of authority over what happens to the animals at rodeos. And what this board has said, that this is an issue that deserves attention, that deserves consideration. And so we're not going to decide at the board meeting what we're going to do at rodeos. We've put this issue to the MDC, which is where it appropriately should be, to do some research into this